Joining us, everybody. Opened up a minute early just we had so many people waiting in the waiting room. Want to make sure that those folks get in. And we will be starting in earnest momentarily. All right. I see 2 o'clock on my clock. I think our waiting room is empty. Anyone who's not logged in will hop in as we go.
Great,
I
go
want
for it.
to thank everybody for joining us today. Welcome everyone to this presentation on the new observation status appeals process. My name is Matt Shepard. I'll be moderating today's session. Our presenters today are Center for Medicare Advocacy Litigation Director Bers, Senior Attorney Wey-Wey Kwok, and Associate Litigation Director at Justice and Aging, Carol Wong. JIA created that nifty appeals flowchart that we sent out earlier today that I hope everybody got. We also have Jeff Wiseman, whose voice you just heard, who's going to help me monitor chat today. So feel free to hop in the chat, say hello. And while you're in there, you can download the resources that I did send earlier today if you didn't happen to get that email. Before we hear about JIA in the center, please bear with me. I'll do a little housekeeping on Zoom, though a lot of us are very familiar with it. As with any online presentation, your audio and video connectivity will be at the whim of your internet. But definitely also make sure you've got the correct microphone and speaker set in your audio controls if you want to engage in live discussion at the end of the presentation. Should you have trouble watching or listening or get disconnected at all, we will be sending a link to the recorded presentation in a follow-up email that you'll get from me. When you are watching today's presentation, note that if you don't want to see any empty presenter boxes while they're not live, you can change your view settings in the view menu at the top right of your screen. As noted, we hope to have plenty of time for Q&A, and on that topic, please note that Zoom has, in addition to the regular chat where I see some of you are saying hello, a questions section. You can pop that box open and type questions in there. I can monitor those and pass them on to our presenters at the end of the presentation. As noted in that regular chat, right up at the top, there should be links to download slides and other resources. If you have any trouble with that, I will also include those with the recording link when we send that out post-presentation. Almost there. Now, a little bit about the Center for Medicare Advocacy. If we move forward to that slide. The Center is a national nonprofit law organization that works to advance access to comprehensive Medicare coverage, health equity, and quality health care for older people and people with disabilities by providing exceptional legal analysis, education, and advocacy, all based on the experiences of the real people who contact the center every day. And you will hear similar about Justice and Aging, as I now welcome Justice and Aging Associate Litigation Director Carol Wong to really get us started. Carol.
Hi, thank you so much for that wonderful introduction. Hello, everyone. For those of you who don't know me, my name is Carol Wong, she, her pronouns. I'm the Associate Litigation Director at Justice and Aging. So slides already advanced. So a little bit about Justice and Aging, in case you're not familiar with our organization. We are a national organization that uses the power of law to fight senior poverty by securing access to healthcare, economic security, which includes housing, and the courts for older adults with limited resources. So since 1972, we focus on primarily fighting for people who have been marginalized and excluded from justice, including women, persons of color, LGBTQ+ individuals, and persons with limited English proficiency. Next slide, please. Great. And then this slide's about our commitment to advancing equity. So to achieve justice in aging, we must advance equity for low-income older adults. Again, in our core focus areas of economic security, healthcare, housing, and elder justice, address the enduring harms and inequities caused by systematic racism and other forms of discrimination. And then also our commitment has us look inward to recruit, support, and retain a diverse staff and board across race, ethnicity, gender identity, sexual orientation, disability, age, and economic class. All right, next slide, please. All right, so I'm going to go over our agenda for today. So first, we're going to talk about the issue. What problem are we trying to address? The problem of long observation status stays in hospitals. Next, I'll talk a little bit about the lawsuit to address this particular issue. And then after that, we're going to talk about the fix, the implementation, the appeal rights that we're all here and I'm presuming interested to learn about. So basically, we'll be talking about the two different kinds of appeals. There's going to be the retrospective appeals. So for those folks going back to a certain date who's had claims accrue, before and during, the lawsuit and while, the regs were being worked out, and then prospective appeals, which are those moving forward. All right, next slide, please. All right, so the problem, as most of you probably know, admission to a hospital is a precondition to payment both for hospital service and post-hospital skilled nursing services, so nursing facility services under Part A, Medicare Part A. So we usually call that like inpatient or status. Now, if a patient is placed on quote unquote observation status, I think the formal term is like outpatient, but everyone calls it observation status. Instead of being admitted as an inpatient, the patient will have to pay for both hospital services and the post-hospital skilled nursing facility services if they need them out of pocket, unless they have other insurance coverage, such as Medicare Part B or private insurance. So those without Medicare Part B are particularly harmed. So in the past, you could have patients with same medical conditions, maybe same length of stay, but one could be designated as inpatient and one could be observation. Also in the past, folks could be designated as observation for days, even, more than a week. And also in the past, the patient had no right to say, to say, the decision about whether to put them in the inpatient bucket or the observation bucket was wrong, and there was no actual way to challenge it. And the slide actually goes in a little bit more detail about the very particular rules about when you would get skilled nursing facility coverage and sort of like all the math that goes behind it. So Medicare requires a 3-day inpatient, so Part A hospitalization, in order to get covered nursing home coverage. That does not include the day of discharge. So any time you're spent in observation does not count. So we have a couple little math problems. So if you're like 1 day inpatient, 2 days observation, even though that's like 3, because 1 day is 2 days were observation, you don't get coverage. Another example, you got 2 days as inpatient, 3 days as observation, again, no coverage. And as I mentioned, those without Medicare Part B may also owe the full quote unquote sticker price for hospital services. So they are sort of doubly impacted. So in the past, they're either folks paid thousands of dollars out of pocket for care if they weren't inpatient for the 3 days, or they just would go without care. All right, next slide, please. All right, so why did hospitals do this? It just seems like a billing distinction. So in the past, there was an auditing program. It was known as the Recovery Audit Program, or RAC for short, that focused on inpatient hospital claims. So there was pressure on hospitals from the government to use observation status to avoid these costly audits. And hospitals were trying to comply with these Medicare billing rules set forth by the government. So the point of the RAC audits was to focus on what the government viewed as law inpatient stays that could have been billed as outpatient observation, which would be cheaper for the government. And then because, Congress doesn't like to spend money for these sorts of things, the RACs were funded on a contingency fee basis. So basically, the more stays the RAC identified that should have been billed as outpatient, the more money they would make. Now, they weren't actually rewarded for being accurate. So there are incentives for the RACs to identify as many claims as they possibly could and to try to claw back as much money as they could. So the RACs only had to return their fees if a hospital successfully appealed the denial of a claim. But there was no penalties when the denials were overturned on appeal, and they weren't required to pay interest on those fees. However, hospitals, they had to pay money back if they got the bucket wrong, the inpatient versus observation bucket wrong. Now, interestingly, before our lawsuit, hospitals actually did have a right to appeal. Beneficiaries did not. So because there are all these audits going on, hospitals were appealing at really high rates. So all the appeals led to a backlog in the system, which actually hurt a lot of smaller hospitals without the resources to hire lawyers to do this sort of work. So there was an incentive for hospitals, particularly smaller, less resourced ones, to use observation as a default. You didn't get audited if you stuck someone on observation. You were totally fine. We viewed it as in the trial, we used the term and the phrase safe harbor. And interestingly, so in terms of how much money a hospital would make based on which bucket a patient got stuck into, hospitals actually get less money generally for patients categorized as observation, but because of the enormous audit threat and putting aside the money, getting in trouble with CMS, hospitals sort of went the more conservative route because you're never wrong if you were never wrong if you stuck someone as observation. So those were past practices. At some point, and I don't actually have the exact date, the auditing practices changed. They're changed under the Quality Improvement Organizations. I think it stands for QIOs. And so the process has changed. So different contractors are doing the audits now. There's a different method of auditing. So for example, they do sampling instead of just grabbing lots and lots of cases. CMS also has changed the rules to try to reduce long observation stays. I think many of you may be familiar with the 2 midnight rule. Before that didn't really exist. And during COVID, the 3-day stay requirement we just talked about was waived. Another change was more and more beneficiaries are on Medicare Advantage, and that never actually had the 3-day stay requirement. We've heard some anecdotal evidence that recently there have been fewer of these, week-long, 2-week-long observation stays. However, there's a lag in the actual data we can get. So we don't have, concrete information right at this point showing whether these changes have led to a reduction in these very long observation stays. All right, next slide. All right, the lawsuit. So Center for Medicare Advocacy, along with Justice and Aging and pro bono counsel Wilson Sonsini, filed this class action on behalf of Medicare beneficiaries who were trapped in these sort of long observation statuses and unable to get their skilled nursing facility care coverage. We filed this class action back in November 2011, litigated it for a very long time. The case was initially dismissed in 2013, went up to the Second Circuit, reversed and remanded, back down in 2015. Lawyers did a lot of work in the interim. Finally had a trial in front of a federal district court judge in Connecticut in 2019. Got a decision in the spring of 2020, finding that Medicare violated the class members' constitutional rights when they didn't allow them to appeal their patient status, and that the government had to create a process for class members to file appeals to challenge, that observation, placement in that observation bucket. Well, the government didn't like that, so they also appealed that back up to the Second Circuit. And then finally, in 2022, Second Circuit said, District Court, you got it right. These folks deserve an appeals process. And that's where we landed. Now, it took a while for the government to implement the court's decision. Um, you know, and the delay continued even after after that second appeal. Finally, the district court actually intervened and got the government to start the rulemaking process, to start setting up the processes for appeal. It also took a broad coalition of advocates. Many of you are on this call. To contribute comments that help to shape the rule and to urge the prompt implementation of the rule to create these appeal rights. So the actual decision is that the government violated the due process rights of patients who were changed from inpatient to observations. So the logic is the hospital was applying standards set by the government, set by CMS to make those decisions. So in order to have a due process rights violation, you need to have some sort of government action. And I think it's important to be clear that this is just the right to challenge the decision, not necessarily to guarantee you go back to inpatient status. You just have the chance to show CMS, like, you know what, it was wrong. I should have been inpatient. You know, you put me as observation. I should have been inpatient, and to like present evidence and arguments that they got it wrong. And we'll talk more about that later in the presentation. All right, next slide, please. All right, so there's two types of appeals, as I mentioned in the beginning. There's the retrospective appeals for those who actually had no appeal right. So like going back in time to January 1st, 2009. So this is like, even before the lawsuit, during the pendency of the lawsuit, during the appeal of the lawsuit, while CMS is like writing the rule, all that time period where actually an appeal right didn't exist. So if a patient decided to file one of these retrospective appeals, they could possibly receive refunds for any out-of-pocket payments for their nursing home care if they win, or if it was someone who didn't have Medicare Part B and sort of was doubly hurt because their hospitalization wasn't covered, they could also get refunds from the hospital. And then these retrospective appeals are only available for a closed period of time. So January 1st, 2009 from February to February 14th, 2025. That would cover only those hospitalizations. Everyone else moving forward would have these, what we call prospective appeals. So moving forward, starting now, so like this appeals process exists. And then you would fall, and if you're hospitalized now, you would fall under that prospective appeal bucket. Again, it pretty much is rough, and we'll talk about it more in more detail, roughly the same process. If you win, you could get your nursing facility coverage covered, and this prospective appeal process will be available, indefinitely. All right, so I will turn it over to our next speaker.
Great. Thanks so much, Carol. Can we go to the next slide, please? So I will be speaking about the retrospective appeals process, which became operational a few weeks ago on January 1st. And one disclaimer I just want to say up front is that my colleagues, Carol and Wey-Wey and myself, are class counsel in the court case representing the Medicare beneficiaries who are members of the class. So this webinar is geared towards giving information to beneficiaries, that is to patients, their families, other people who help them. We can't give advice to medical providers like hospitals about compliance or billing or other technical issues. Providers will need to consult with their own compliance personnel or legal advisors. That said, as part of this overview of these appeals, you'll see that medical providers can assist beneficiaries in certain ways when they're appealing. So the information here might be of interest to providers so they can give that assistance to beneficiaries. And also on that note, since this is this webinar is aimed at beneficiaries and people who help them. We're trying to stay away from jargon and acronyms that you often hear in Medicare. Some of it is unavoidable. You've already heard some like RACs and things like that. The topic here is a little complicated by nature, so we're trying to present it in understandable terms. If you don't understand something, please go ahead and type your question in the Q&A box. We will try to answer it. Also bear with us because these regulations and these processes are brand new, we're still learning them as well. So if there's something we're still trying to figure it out, we'll be happy to get back to you when we do. Finally, one more overarching point that I wanted to get into before I get more into the details is that the court made a point of saying that these appeals will be largely similar to existing Medicare appeals. And I've been saying from a practical point of view, that's the good news and that's the not so good news. The Medicare appeal system is not the most user-friendly system out there. Those of you who are familiar with it probably know that. It has its difficulties. On the other hand, it is the system that we have. It exists. It does give people rights, and it's what we're used to. So this process that has been won in the court case is not giving people anything better or anything worse in this case than what exists with Medicare appeals. Okay, so now moving on to a little more detail about the retrospective appeals. If we could go to the next slide, please. As Carol said, these are for class members who did not have a process available at the time that their rights were violated. And this slide reviews who can get a retrospective appeal. I've paraphrased who is eligible, and this is probably the most complex concept in the case in the webinar, even as a paraphrase. But to run through it, who is eligible for a retrospective appeal? People in traditional Medicare. This does not apply to people in Medicare Advantage plans. As Carol mentioned, Medicare Advantage plans, virtually all, if not all, waive the 3-day stay requirement for nursing home coverage. And it's generally tends not to be an issue there. But in any case, this case applies only to people in traditional Medicare who are reclassified from inpatient to observation on or after January 1st, 2009. And if you're asking yourself, why is the case limited to people only who were reclassified, not people who might have been on observation the whole time? That's actually because it has to do with an issue in constitutional law, which I won't get into in detail, but basically there's a requirement that there be some form of government action, and the court found government action is only limited to those reclassifications. Essentially, the court found that that's when the hospitals are trying to comply with government mandates. At that point, believe me, there was a lot of briefing and argument over this issue, but this is what it came down to being limited to. So it is for people who are reclassified from inpatient to observation on or after January 1st, 2009. They received a notice showing the hospital was not covered by Part A. That could be either the routine Medicare summary notice that people get in the mail, or they can get it online. They can go online and create a My Medicare account and get it that way. Or they may have received a MOON notice, Medicare outpatient observation notice, MOON notice. Any one of those is okay, Medicare summary notice or MOON notice. And then either they stayed in the hospital for at least 3 days, but were an inpatient for fewer than 3 days, and that's counted as Medicare counts days. They don't include the day of discharge. So it's 3 days, not including the day of discharge. And they were admitted to a nursing home within 30 days after leaving the hospital, or they were not enrolled in Part B at the time of their hospitalization. And those two Either or groups at the bottom is really how I think about the class. There are the nursing home problem people. That's the people who didn't have 3 days as an inpatient, but then went to a nursing home without Medicare coverage. Or there are what I think of as the no Part B problem people. And note that there's no length of stay requirement for that group. As long as you did not have Part B when you were hospitalized and you meet the other criteria, you'd be in that group. Next slide, please. So how to request a retrospective appeal. This is a much simpler slide. Medicare has created a form, and there is a link to it on the slide, as well as in the resources that you were sent. You don't have to use the form. There are also instructions which are linked to about what information to include. You send in the form or the information by mail or by fax. There is no online way to do it. It has to be by mail or fax, and it is sent to the eligibility contractor that Medicare has hired for this purpose. That's this Q2 administrators. That's the eligibility contractor that Medicare is using. Next slide, please. So here is the information that will be included, some of the basics, name, Medicare number, etc. And you are also highly encouraged to include whatever you can of this other information: hospital records, nursing home records, the relevant Medicare summary notices, bills, and proof of payments that you made. It can also be payments that a family member or a friend made for you. Medicare has specified that those count as out-of-pocket costs as well. And send in as much as you can. Since you have some time, the deadline for these retrospective appeals is not until about a year from now, January 2nd, 2026. So there's time here. I'd encourage people to take the time, gather as much information as you can. You'll also have opportunities to supplement information later. And the eligibility contractor is also supposed to help people get required medical records. Next slide, please. You can also include a written statement or argument from you, from a doctor who treated you, about why the inpatient admission was correct. You'll want to be arguing that the doctor who admitted you as an inpatient got that right, that the hospital staff who reclassified you as observation was not correct. I'm not going to go too deeply into the standard now, but this slide has the language from the 2 midnight rule, which is in the regulations and talks about when inpatient admissions are appropriate. Lawyers or advocates, their citations to that regulation and the Medicare benefit policy manual on the bottom right of the slide. Notice that this is a forward-looking standard. Was there a reasonable expectation at the time of the doctor's inpatient admission order that the patient needed medically necessary hospital care crossing at least 2 midnights? And there was a slightly different standard for older hospitalizations before the 2 midnight rule. Next slide, please. As for when these retrospective appeals need to be submitted, as I mentioned, people must request these appeals no later than January 2nd, 2026. We haven't verified that date with the Department of Justice. I think at the last webinar, we were still making absolutely sure that was right. That is the correct date. There will also be good cause reasons allowed for later filing under the usual rules Medicare uses for late appeals. And some examples in the regulations that are used for that are listed on this slide. But the general deadline is January 2nd, 2026, as mentioned, about a year from now. So there is time to submit these retrospective appeals. And they, as Carol mentioned, they cover hospitals dating all the way back to 2009, and they will cover hospitalizations going all the way up to February 13th of this year, 2025. And then that's when the prospective appeals will take over. Next slide, please. So with having a full year, almost until the deadline to submit these appeals, what can people who think they're in the class do now, or should they do now, to sort of prepare the best case that they can? What we've been recommending is for that people gather the records that they're going to want to submit, and we've listed on the slide the likely relevant records here. We've also listed a website on this slide with helpful information about requesting your medical records. So for example, here in Connecticut, if you're requesting your medical records in support of an appeal under the Social Security Act, they must be provided free of charge. And Medicare is a program under the Social Security Act. Also in Connecticut, if you provide an affidavit stating you're not able to pay for your records, they must be provided free of charge. Now, this all depends on what state you're requesting your medical records from. So I encourage you to check the law in your state for requesting medical records. The general rule is that reasonable fees can be charged for paper records, but nowadays there's also often ways to get records electronically. Medicare understands there may be hurdles and challenges in getting access to older records, and it's stated in its final regulations that the eligibility contractor must work with beneficiaries and providers and Medicare contractors whenever necessary to help obtain information. Now, one question we've been getting a lot is, what about a situation where there may not be any medical records anymore if it's a very old claim? What we have been telling people is submit whatever you can to show what happened, including, so let's say, for example, if you even have partial medical records, submit those. Submit any notes that you or your family member may have taken, especially at the time that the events were happening. Submit your own written statements about what happened from you or family member, or if you get up to a point where you're having an ALJ hearing, your own testimony about what happened. Any statements you can obtain from treating doctors as well. Basically, do the best you can to show what happened in the absence of a medical record. Next slide, please. Who can help? This is mostly the same rules as for other Medicare appeals. You can appoint almost anyone you want to act as a representative. There is a form to do so, link to that form there. Some people are basically already authorized, like someone with power of attorney. If the beneficiary has died, you will need to show authorization to act for the deceased person. So documentation that you've been appointed to act as the representative of the estate, or if there is no estate, whatever rule allows you to handle the affairs for that person. The difference from other Medicare appeals is that providers like hospitals and nursing homes cannot be parties to these appeals and cannot represent beneficiaries. However, they can assist and they can provide information. Next slide, please. The actual process. So the single entry point for these retrospective appeals is this eligibility contractor, which decides only if you are eligible to appeal. Essentially, are you a member of this class that the court says has this appeal right? If they decide you are not, you do get one more try with them to show that you are eligible. If you are eligible, then that contractor will automatically forward your case to the appeal contractor, which will decide the substantive question, was the inpatient admission correct? And then it's like a regular Medicare appeal. And I would refer you to the excellent flow chart that Carol's organization, Justice and Aging, made, which is in the materials, which shows the different levels of appeal. And then it really becomes like a regular Medicare administrative appeal up through the different levels. Next slide, please. So there's a few examples here, which I'll just run through quickly to show, who can appeal in these circumstances. This is really what I consider the classic nursing home problem. Ms. B is enrolled in traditional Medicare, had a bad fall at home. After going to the emergency room, was hospitalized from June 30th to July 15th, 2015. Initially admitted as an inpatient, but reclassified as an outpatient receiving observation services on July 1st, 2015. Went to a nursing home on July 5th, 2015, where she received 4 weeks of skilled care, including physical and occupational therapy. But since she didn't have the 3-day stay as an inpatient in the hospital, she didn't qualify for Medicare coverage of the nursing home stay and paid around $10,000 out of pocket to the nursing home. Is she eligible to appeal? Next slide. Yes, so she should submit a request definitely for a retrospective appeal. She was reclassified during the correct time period. She should have received both a Medicare summary notice and the MOON notice, the outpatient observation status notice. People don't always get those, but if she got them, she could use that and or the Medicare summary notice. She was in the hospital for at least 3 days, but inpatient for fewer than 3 days. She also received skilled services at the nursing home and has out-of-pocket costs, so she likely qualifies for Medicare coverage at the nursing home. That's another piece, is that you do have to qualify for the services you got at the nursing home for that coverage. So she has a good reason to appeal. To prepare, she should request the hospital nursing home records, gather all the records. She could get a written statement from the doctor and submit all of her materials to the retrospective appeal eligibility contractor. If she were to eventually win, Medicare should cover the nursing home stay and she should receive a refund from the nursing home minus any co-insurance amounts that she would be responsible for herself. Next slide, please. This is the classic Part B problem. This is regarding a beneficiary in traditional Medicare who went to the emergency room for stomach pain and was hospitalized just from April 17th to April 19th in 2018. And at that time, he was enrolled only in Medicare Part A, did not have Medicare Part B. A beneficiary like this might think that going to the hospital he'd be safe because he had Medicare Part A, which is called hospital insurance. But he was admitted as an inpatient and then reclassified as an outpatient receiving observation services. The hospital gave him a MOON notice explaining he was on observation status, and he later got a bill from the hospital from around $15,000. He told the hospital billing office he couldn't afford to pay that much and wound up paying a discounted amount of $5,000. Is he eligible to appeal? Next slide. Yes, he should definitely put in a request for a retrospective appeal. He meets the criteria, reclassified. He has these records. He was not enrolled in Part B, has out-of-pocket hospital costs, and he should submit a request. If he wins, Medicare would cover the hospital stay, and he should receive a refund for his out-of-pocket costs minus any deductible or co-insurance amounts that he was responsible for himself. Next slide, please. Okay, this is an example of someone who, like the first example, was hospitalized after a fall, was in the hospital for at least 3 days, but did not have 3 days as an inpatient, but she couldn't find a nursing home she could afford after her hospitalization and was discharged home. She does not meet the criteria for an appeal because she was not admitted to a nursing home within 30 days of her hospital discharge. That's one of the criteria for a retrospective appeal. And so this is also a way in which these appeals are like other Medicare appeals. They only concern services received. This case, these appeals don't help people who didn't actually receive the Medicare services. She is not eligible to appeal for a retrospective appeal. Okay, so we can go on to the next slide, and I will turn it over to my colleague, Wey-Wey Kwok, for prospective appeals. You're on mute.
Okay, there we go.
Hi, okay. Hello, everyone. Okay, so we are going to shift now to talk about prospective appeals, the process that will be available going forward. On this slide, we've cited the regulatory provisions that govern the prospective appeals for your reference. And much of what I'll be talking about is based on these new regulations. Next slide, please. So the district court's order requires the agency to establish, excuse me, and implement an appeals process going forward for eligible Medicare beneficiaries who disagree with a hospital's decision to reclassify their status from inpatient to observation. Importantly, hospitals will have to give Medicare patients notice about the status change. And if the patient disagrees with it, they will have the opportunity now to appeal the change in status even before they leave the hospital. So in other words, they can request an expedited or a rapid appeal. Now, if they win this rapid appeal, they'll know earlier on that they do at least meet that 3-day inpatient hospital stay requirement to qualify for nursing home coverage if they do need skilled nursing or rehab after they leave the hospital. Now, according to the agency, the appeals process will be operational, meaning up and running, as of this coming February 14th. The appeals process will be permanently available from that day forward. In addition to the expedited or rapid appeals, a standard appeals process will also be available to eligible patients. Next slide. Okay, so who will be eligible for prospective appeal rights under the new regulations? Well, to be eligible for this particular appeal, a person has to be in traditional or original Medicare. As Ali mentioned, this appeal does not apply to someone enrolled in a private Medicare Advantage plan. The person must be admitted to the hospital as an inpatient, but then later reclassified by the hospital specifically as an outpatient receiving observation services. In addition, the patient must fit into one of two categories. The first category would be somebody who has been admitted to the hospital for 3 or more consecutive days, but classified as an inpatient for fewer than 3 days. So for counting this, they apply the same rules for determining coverage of nursing facility services. So the date of discharge from the hospital is not counted in calculating the 3 consecutive days. Someone in this first category may have an interest in appealing because having their status switched would effectively disqualify them from being able to have their nursing home stay covered by Part A after they leave the hospital. Now, the second category of persons who have a right to a prospective appeal are those who are not enrolled in Part B coverage at the time of their hospital stay. Now, if someone does not have Part B, they could be held financially liable for the full cost of their hospital stay. Next slide, please. Okay, under the new regulations, hospitals must deliver a valid written notice to beneficiaries who are eligible to appeal. And CMS, the Medicare agency, has developed a new standardized notice that hospitals will be required to use. It's called the Medicare Change of Status Notice, abbreviated here as MCSN. Now, this notice is specifically designed to let eligible beneficiaries know that their status has been changed to outpatient on observation and that their hospital stay will be billed to Part B, Medicare Part B instead of Part A. The notice informs them that this change could impact their hospital bill because under Part B, they have a 20% copay for their hospital services, which could end up being either higher or lower than the inpatient deductible under Part A. So a tip here, beneficiaries or their representatives could check with the hospital's billing department to get a better idea of what the difference in cost would be. Now, people who have purchased a Medigap supplemental policy that covers their Part B cost sharing, they may not feel much of or any impact at all on their hospital bill. Now, the notice also informs patients who don't have Part B that they will be charged the full cost of their hospital stay. And it's very important that this notice also lets eligible patients know that the status change means that Medicare won't pay for their skilled nursing home stay after leaving the hospital. And finally, it provides information about their appeal rights, how to request an appeal from the qualified independent organization or the appeals contractor, and what to expect. So the change of status notice is a targeted appeals notice. It's delivered only to those beneficiaries eligible for this particular appeal. It's separate and different from other notices that the patient might get from the hospital, including the MOON or the Medicare Outpatient Observation Notice. That notice doesn't talk about appeal rights, and it's only required to be issued after someone has been on observation for 24 hours. Next slide, please. So when do eligible patients receive that change of status notice we just talked about? Well, the regulation says that they must receive the notice as soon as possible after they become eligible to appeal, and no later than 4 hours before their release from the hospital. So let's walk through a few scenarios on how this could play out. Okay, in scenario number 1, we have someone who is formally admitted as an inpatient on Monday, and the hospital changes their status to outpatient observation on Tuesday. And then sometime on Wednesday, they are discharged. Now, in this situation, the change of status notice is not required because the patient was not there for 3 days. Since, remember, the day of discharge is not counted. Okay. In scenario number 2, we again have someone who is admitted as inpatient on Monday and switched to observation on Tuesday. Now, this person is discharged on Thursday. Well, in this case, the patient could get the notice on Wednesday, which is their 3rd day, if the hospital is certain that the patient's stay will cross another midnight. But it is conceivable that the hospital is thinking about or even planning, preparing to discharge the patient on Wednesday. If that happens, it would be the same as scenario number 1, where the patient isn't eligible to appeal. So a notice is not required at all. So in scenario number 2, it's permissible for the patient to get notice at least 4 hours before they are discharged on Thursday. Okay, so let's go to scenario number 3. And this is someone who has no Part B. And they're admitted as an inpatient on Monday, and their status is changed on Tuesday, and they're discharged on Wednesday. Well, here, this patient is eligible to appeal immediately, and they should be given the notice as soon as possible after their status is changed. Probably on Tuesday, they should get it. But it doesn't matter, that the fact that they weren't there for 3 days does not matter. Now, the notice is valid if it's timely issued and the eligible beneficiary or their representative has signed and dated it to indicate that they have received it and can comprehend its contents. Now, if they refuse to sign, the hospital may make an annotation on the notice indicating their refusal to sign. Next slide, please. Okay, so what happens next? How does an eligible patient appeal? Now, they have a right to request an expedited determination by the appeals contractor that has an agreement with the hospital. And, that contractor would make an independent decision about this. They should make that request by phone or in writing to the QIO before they're released from the hospital. Now, after receiving the appeal request, the QIO must examine the relevant medical records, and the hospital has to supply all of the information that the QIO needs to review the case as soon as possible, but generally no later than by noon of the day following the person's request. At the QIO's discretion, a hospital can provide information verbally over the phone, but they have to keep a written record of what was communicated to the contractor. The QIO must also ask for the views of the beneficiary or their representative, and they should make themselves available to discuss the case, typically over the telephone with the QIO. The patient may, but is not required to submit written evidence to be considered by the QIO. The QIO also has to allow the hospital to explain why they think the reclassification was appropriate. Now, once it receives the requested pertinent information from the hospital, the QIO must issue a decision within 1 calendar day. And then they have to notify the patient of the decision by phone, followed by a written notice explaining the basis for their decision and the payment consequences, and the beneficiary's right to request an expedited reconsideration. And the QIO also has to notify the hospital of the decision and the nursing home as well, if the patient is in a nursing home at that point. The QIO's decision is binding on the beneficiary, hospital, and Medicare's administrative contractor that processes claims. And the only exception to this is if the beneficiary is dissatisfied with the decision and decides to appeal further. Next slide, please. So if the patient is dissatisfied, they can timely request an expedited reconsideration from the QIO in writing or by phone by noon of the day following the decision. The QIO in turn must offer the beneficiary and the hospital an opportunity to provide further information. And again, the beneficiary or their representative must be available to answer any questions or supply information that the QIO requests. The beneficiary and the hospital may, but they're not required to submit additional evidence at this level of appeal. The QIO has 2 calendar days to issue a reconsideration decision after receiving all the information they need, and they must notify the patient, hospital, and nursing home, if applicable, of the decision, followed by a written notice explaining their reasoning. And also letting them know they have a right to appeal to the next level, which is for an ALJ hearing if they're dissatisfied, if the beneficiary is dissatisfied. So I want to note here that beneficiaries are not protected from financial liability while pursuing these expedited appeals. Financial liability protections apply to patients pursuing expedited appeals of inpatient hospital discharges, but not to patients who are appealing their status change. The hospital is, however, prohibited from issuing them a bill until after the expedited process is complete. Next slide, please. So we've covered expedited appeals, but what if an eligible patient wants to appeal after they've already left the hospital? Well, the regulation says that an eligible beneficiary can still make a standard or untimely appeal request at any time. And that's exactly how it's stated, that they can appeal at any time. So they can appeal to the QIO after they have left the hospital, or when they're already in a nursing home, or even after they've left the nursing home and have faced, a bill for that nursing home stay. Now, for untimely requested appeals, the QIO has a slightly longer time frame to issue decisions. They have 2 calendar days to issue an initial decision after getting the patient's records, and they have 3 calendar days to issue a reconsideration if requested. Billing and protections do not apply to these standard or untimely appeals. I do want to note here that after the reconsideration level in both of the, expedited and standard appeals, after that, the rules followed the regulatory requirements and timeframes for standard Medicare appeals at the next 3 levels for the ALJ, the appeals council, and then judicial review. Next slide. So who can help with prospective appeals? Well, it's very similar, basically the same as what Ali was talking about for the retrospective appeals. Beneficiaries can appoint an authorized rep, such as a trusted friend, a relative, or an attorney for these appeals. And there's and Ali's slide linked to a form that can be used. And again, providers cannot act as appointed representatives for a beneficiary in these appeals. They can, however, lend assistance and support by providing records, answering questions about status change and the appeals process. They can help someone connect with their local SHIP program or contact 1-800-Medicare or the QIO. Knowing what is documented in the medical records can be really helpful in these appeals. And at the beneficiary's request, a hospital must furnish a copy of or access to any medical records and information that it has sent to the QIO, including, documentation of what was verbally communicated to the QIO about their case. If the beneficiary requests their records, then by the next close of the next business day, the hospital needs to provide access, and hospitals can charge a reasonable amount to cover copies and delivery costs. Next slide, please. So what criteria will be applied to these appeals? In other words, what will the QIO and other reviewers be evaluating to decide if someone met the criteria for inpatient hospital coverage? Well, one thing, they will need to ensure that there is an actual inpatient order by a doctor. The hospital, must formally admit a patient after a doctor orders inpatient care to treat the patient's illness or injury. Another key inquiry is whether the treating physician had a reasonable expectation at the time of admitting the patient that the person needed medically necessary hospital care crossing at least 2 midnights, right? So yes, this is known as the 2 midnight rule. And according to CMS policy, inpatient payment is appropriate if the 2 midnight rule is satisfied. So the reviewer will be deciding whether the admitting physician's expectation was reasonable based on, the documentation in the medical record. Factors considered in making this decision can include, what was known about the patient's medical history, their medical needs, the severity of their clinical signs and symptoms, the medical predictability that the patient might suffer an adverse event. So if it looks like the hospital kept the patient there for tests or studies that normally would be outpatient services or just weren't available over the weekend, the reviewer would likely be evaluating whether the patient was so sick that the hospital couldn't risk sending the patient home. So a little note here to emphasize that it's the clinical information available at the time of inpatient admission that's key. This is important because sometimes people go to the hospital quite sick with concerning symptoms and medical histories, but they might unexpectedly improve after a day or two. But reviewers should be focusing on the evidence at the point of time of the inpatient admission. And the agency's policy specifically states that QIOs, quote, do not take into account other information, for example, test results, which became available only after the admission decision was made, except in cases where considering that post-admission information would support a finding that an admission was medically necessary. Okay, that's all I have. So I think we will now have some time for questions and discussion.
Sure, let's bring up all of our panelists. We definitely have questions aplenty in the queue.
One thing Matt, I'll just say right off the bat, just because I think it bears repeating, just to avoid confusion, is that these appeals processes are, like I said, one of the criteria is that the patient needs to have been reclassified from inpatient to observation. So it does not apply to people who were on observation the entire time in their hospitalization, or to people who were only reclassified from observation to inpatient. It has to be, you know, the reclassification from inpatient to observation. Also raises the question, how does one know if one has been reclassified, especially for the retrospective appeals? You know, so prospectively now people will be getting these notices. But for the retrospective appeals, I mean, this is part of the medical records challenge, because when you do a normal medical records request, you may not get those kinds of records that show exactly what the status, the patient status orders were. So we do recommend that you specifically ask for those records that would show that. It may take more than one try to get that, but that is something that sort of needs to be kind of nailed down. Was there a reclassification from inpatient to observation? Another thing I just wanted to say up front, sort of before we open the floor, is just that reminder again about our kind of inability to give advice about hospital requirements and their compliance issues. It looks like someone in the chat already put a resource for hospitals, and you know, again, we just are limited in our ability to advise there, but you know, would say, you know, go to your usual channels for compliance resources for hospitals. But I will turn it back over to Matt now.
Thanks, Sally. You actually tackled several of the questions in the questions panel. So well noted. On the topic of records, though, and the difficulty in obtaining them, several people have wondered or pointed out that hospitals close, hospitals get sold, nursing homes close. What do we do if something like that happens? Is it still possible to engage in this process?
Yeah, the preamble that when the agency put out these regulations, they addressed that issue in the preamble to the regulations, because people had brought that up when they submitted comments. And I don't have it right in front of me. What they basically said was usually there's a successor. So if you know, if there's a new owner, then whoever the new owner is usually has takes on the obligations of whoever the old owner was. So you may have to do some tracing to find out who is the new owner that took on the obligations. But those are the sort of things that you might have to look into. If you need assistance with that, I mean, that's the sort of thing where you may need some assistance, whether it's, you know, legal assistance or assistance from a SHIP counselor. But you know, if the obligation may still be there, it may not just be with whatever the original provider or corporation name was. There is some guidance about that in the preamble to the regulations that were put out by the Medicare agency. I don't know if Wey or Carol had anything to add there.
All right, thank you very much. If you don't mind, I just want to take a moment to mention that Susan Jaffe from Kaiser Health News is on the webinar and has been covering this issue for literally years, decades. And if anybody is planning to undertake an appeal in this process, she would love to speak with you. You can reach her at Jaffe, JAFFE.KHN@gmail.com. Thank you for that interruption. Another theme I saw here was publicity. We saw it in the chat and the questions panel. Who is talking about this besides us here and Ron Hirsch? How is news of this getting out?
Well, CMS has information on this now on their website, and I believe, if I remember right from the preamble, also is putting out information in the on upcoming Medicare summary notices, and Medicare and I guess already went out, but there I guess the next Medicare NU, and also I believe said they were going to be putting out information to SHIP programs. So again, I'm sorry, I don't have that in front of me, but I know that there was information on what CMS is doing to help put it out. We are certainly trying to spread the word, and we ask, for assistance from anyone who can help us spread the word as well. But CMS is doing beneficiary outreach. They are training their 1-800 Medicare agents as well with information. Do you remember more specifics on how they were doing information spreading? Besides, I know 1-800 Medicare, SHIP programs, Medicare summary notices, believe
That's-
Medicare and you.
Yeah, I think that's all I've heard of. I don't have.
And then, and then going forward, people will get the note, going for the prospective appeals, people will get the notices.
Someone suggests, is there going to be an MLN article perchance?
There actually is an MLN article. I will try to put that in the chat. I did see one. And there will be, Carol can help with this one. There will be a NICLR webinar. Carol can explain what that is and what it stands for in February, I believe February 26th. Carol, can you?
Yeah, sorry. I was trying to pull
Yes.
up the link to NICLR just to put it in the chat. It might be just easier for folks who aren't familiar with NICLR. So basically, that's the National Center on Law and Elder Rights. In conjunction with ACL, they provide trainings on a whole bunch of topics, including this one, as well as housing, consumer protection issues that impact older adults. And I will put the link in the chat. Just give me a second.
Right. In terms of like someone saying people not concerned that there is even such a thing as observation. So, I mean, that is what, so going forward, people will be told. I mean, so, people who have the right to appeal, hopefully, if things are done correctly, will get the Medicare change of status notice telling them that they have the right to appeal. Even those who don't have the right to appeal are supposed to get the MOON, the Medicare outpatient observation notice, at least telling them that they that's been going on for several years. Congress made that a law saying you do have to at least be notified once you receive a certain, I think it's 24 hours worth of observation services. The hospital is supposed to provide a Medicare outpatient observation notice, which at least describes what it is. But because before that, people were absolutely getting slammed without any knowledge of what was going on. And so Congress stepped in with requiring the MOON notice. And now, now at least the people who going forward have the right to appeal should also get the appeal notice.
Right. The Medicare change of status notice, hospitals are required now under the conditions of their participation in Medicare to provide this new notice.
All right. Thank you all.
The MLN.
A question that we always get on every webinar about anything in Medicare. Does this apply to Medicare Advantage?
No, it does not. The terms of the court's order, you know, specifically stated, that this only applies to beneficiaries under traditional Medicare. And the rule under the CMS stated in the rules that, Medicare Advantage enrollees have rights and protections that are set forth in that different part of the regulations, and that when a Medicare plan refuses to provide or pay services in whole or in part, including the type or level of services that the enrollee believes should be furnished or arranged for by the Medicare Advantage plan, that's considered an organization determination, and they have processes for review specifically, for organization determinations. And so these particular appeals do not apply to them.
Thank you.
That's right. They have recently clarified that the issue should be appealable. It generally doesn't come up as much because of the lack of the 3-day stay requirement for people in Medicare Advantage. I just put the MLN in the chat.
Yeah, if they were ever going to do anything similar for Medicare Advantage enrollees, they would, have to go through separate rulemaking to do that.
Thank you very much. What about care setting? Does this include psychiatric hospitals? Bonnie asks.
So it's defined, hospital here is defined as any facility providing care at the inpatient hospital level, whether that care is short-term or long-term, acute or non-acute, paid through the prospective payment system or other reimbursement basis, limited to specialty care or providing a broad spectrum of services. And that it also includes critical access hospitals. So I would say under that, yes, psychiatric hospitals would apply.
Thank you. Sort of a cynical question. So now we've got this appeals process. What's to stop hospitals from just putting people in observation and not changing them at all?
It could happen. They are supposed to comply with Medicare rules. So they should comply with Medicare rules. That's what should stop them from doing that. They should, that's a compliance issue for hospitals.
Oops, sorry to interrupt, but on that topic, we had several people ask, and maybe they missed it, we went over it quickly. What's the benefit to hospitals for observation status? Why do they even do it?
Yeah, well, that was something, I mean, Carol addressed that a little bit, and I think I saw a little bit of conversation in the chat, like, because that I think there is sometimes a misconception that hospitals get paid more for observation status, but actually they get paid, hospitals are paid more for inpatient claims than for outpatient observation claims. But it's really, again, I should say, a matter of compliance. And although the sort of past practice of these very aggressive audits has stopped, there was reform there, and the old RAC program as it used to exist doesn't exist anymore. That's what sort of drove the problem up to the forefront, where hospitals were trying to comply with being audited all the time. Carol, is there anything else you would add to that?
Yeah, no, it's just to reiterate that from the hospital's point of view, observation isn't, well, until this point with the current appeals process, it wasn't wrong. You would never get in trouble for placing somebody on observation status, like trouble from like the government. It was really like auditing pressure and scrutiny they were trying to
Right.
avoid. And as I mentioned, also like, some small, like large hospitals, large hospital systems have money and resources to hire lawyers to, file appeals, and navigate this. Smaller hospitals, hospitals with less resources are less likely to do that. Observation is really a safe harbor for them. If they just made people observation, they wouldn't get in trouble. They wouldn't get in trouble.
I should also say that another thing that we continue to work on, both Justice and Aging and Center for Medicare Advocacy, is, this is a piece of our more comprehensive work on observation status, and we've been working on more comprehensive observation status reform for years and will continue to do so. This is only one aspect of it. So we felt it was really important that as long as observation status is affecting beneficiaries' coverage, which we don't think it really ever was intended to do, but it is very much, it was preventing still, prevents people from getting needed health coverage, that people should absolutely need to have the right to appeal when it's wrongfully placed on them. People need to have the right to appeal that. But there's also just, other continuing issues. There's still people who don't have the right to appeal, and there's continuing issues with observation status, which our organizations continue to work on. So there's larger advocacy efforts to, for example, change the law so that any time in the hospital would count towards the 3 days, no matter how it's categorized. There's advocacy efforts to simply get rid of the 3-day stay requirement for nursing home coverage, so that people in traditional Medicare would essentially be in the same position as people in Medicare Advantage and not have to meet that requirement. Those would be congressional changes made by Congress. But in the meantime, this was an important right to establish because people were, as I said, not able to go to get care that they needed at nursing facilities, or having to pay thousands and thousands of dollars for it.
Thank you. We have a couple live questions, but I want to ask one more because several people have asked it. And it's about changes during COVID. Weren't all these rules changed? And someone asked, are they back to normal?
Yeah, it was a temporary invocation of the ability of nursing homes to waive the 3-day stay requirement that was invoked during the public health emergency. And since the public health emergency ended, that is no longer in effect. And while it was in effect, it really, from what I understood, wasn't something that really like an individual patient could invoke and say like, I want to go to a nursing home and I don't want the 30-day stay requirement to apply to me. It was something that a nursing home could apply to its patients, to its claims. It wasn't really a right of the patient, at least the way it was implemented. But it did show during that time that it worked. As far as we could see, it didn't cause any big disruptions in Medicare administration or costs. And I believe we put out some alerts and materials on that issue. It sort of provided a real world test of the fact that the traditional Medicare program can operate just fine without the 3-day stay requirement. So it is back now, but it was for a while suspended during COVID.
Thank you, Holly. All right, let's see if we can have somebody else here ask a question besides me. Taryn Rollison, your hand has been up. Do you have a question? Or is that an accidental hand? Looks like an accidental hand. I'll go to Darlene. Hello?
Yes, this is Darlene.
Ah, excellent.
And thank you for bringing up the historical aspects of the appeals that have been made mostly up in the New England area. And I've been around long enough that I was aware of those. I do think doctors may be discouraged from writing inpatient admission at the beginning of the stay based on this. That would be my only concern. I saw that with home health care way back when face-to-face was implemented, it did reduce the number of admissions to the nursing facilities. And we saw patients going home because they did have a face-to-face and the home health care was put in place, which is excellent. Believe me, I'm a firm believer in it, but they went home too soon. So that would be one of my concerns. And the other one was there was a reference to payment consequences. And I've never heard this during any kind of an appeal that you would really reference the financial impact it was going to have on the patient. And I don't know if that was the intent of that clause or not. So if you could expand on that, I would appreciate it.
When you're just for the second piece, you're talking about appeals, like appeals when a hospital would be audited and appealing things sort of after the fact.
Actually, it was, maybe I understood it incorrectly, but I thought that it was the patient's part of the appeal. You would pull medical records together, and then there would be a statement as to what the payment consequence would be for the patient. And because the room and board, whether the patient has Medicare Part B or doesn't have Medicare Part B, is always going to be passed on to the patient. So I was just curious about that, why the payment element came into play, because typically it was based on just medical necessity or the patient's medical condition at the time of admission and during the course of the stay, if that makes sense. It was on a slide. You don't have
I think I wonder if there's a little confusion. She may be referring to the reasoning for this appeals process.
Yes, that's exactly
in that
correct.
patients have a consequence which is appealable, and that's why the class was narrowed only to these people who would have some sort of a payment consequence.
Okay, I understand now. Okay, thank you.
Okay. And then, oh yeah, as far as doctors being influenced, again, it's a compliance matter, and hospitals and doctors should be following Medicare rules. I will say just a couple of questions that I happened to see fly by about issues when a beneficiary has died. I would say, it's the normal rules for Medicare appeals in terms of who can represent an estate. And so usually there has to be a representative of the estate, or if there is no estate, then whoever is handling the affairs would have to sort of show how they have the authority to handle the affairs, just as they would for a regular Medicare appeal. And then if there is a refund, it would just be as if any other type of refund coming to the estate. It would depend on the state and the state law in that state. So it's really, there's no special rule for this. It will depend on the rules in that state. So may involve some investigation with someone who knows what the rules are. But I think that's as specific as we can get in terms of how to handle it when a beneficiary has died. There just needs to be someone with authority to either formally represent the estate or act under authority under some kind of state rule that allows you to do that.
All right, thank you. You mentioned the appeals process is similar to the appeals process is already in place. Someone asked what the turnaround time is typically for appeals. And if you don't win, do you get a second level, third level, as in the traditional process?
Right. So with the expedited appeals going forward, those are actually the turnaround time is pretty quick. The independent contractor who looks at it at the first and second levels of appeal, if it's expedited, meaning if the patient requests it before they leave the hospital, they'll get their first decision within a day usually, and a reconsideration within 2 days. But after that, then it goes to the third and fourth levels, which, the administrative processing system, they have 60 days, to request those appeals, and the contract, those levels of appeal, the time frame is longer. So,
Yeah, and at those higher levels of appeals that Wey-Wey just mentioned, for beneficiaries, they're generally at the first couple, those 60 days, I think they're generally getting in, they're for beneficiaries, in approximately the 60 days or whatever the time limit is. ALJ hearings for beneficiaries, I believe, are happening in a reasonable amount of time.
yes.
They're identified as beneficiary appeals. It's the next level where that's where the unreasonable delays start, which is
Right.
if you get way up to the Medicare Appeals Council, which is the highest level of appeal. So I don't know how many are actually going to reach up that high. That's where there are backlogs and delays.
Right.
So hopefully things can be resolved no higher than the administrative law judge level.
Right.
And
Because,
yeah,
the ALJ is required to make a decision within 90 days. So we're at least talking about, 3-4 months at that point, after the
right.
expedited. Yeah.
And the administrative law judge is actually where you get to speak to a person, talk to a human being back and forth as well.
All right, thank you for that. We have many more questions and not much more time. So I think I'll end with definitely a beneficiary-centered question here. Marcella asks, or states, this is nice information for the legal world, but in the real world, having the energy and capacity to get assistance when you're in the hospital in whatever status, is that really realistic? In the real world, how would you recommend that a person who wouldn't be able to afford an attorney get help doing this?
I would recommend that it be done in the same way that a person might do so for a discharge appeal. So, before these appeals ever existed, Medicare gives everyone the right to appeal a discharge. You get a notice, an important message from Medicare. You have the right to appeal if you think you're being sent home from the hospital too soon. And you have a right to appeal that with help from certain people, whether that's a family member or a SHIP program that's the free Medicare counseling that's available in states. The difference here being that the hospital itself can't help, but they can help guide you through the process and give you information. So it would what I would recommend is getting help from hospital personnel, at least to get advice. Relying on family members and advocacy, whether that's an advocate within the hospital to point you in the right direction or to call the state SHIP program to get assistance that way. Do you have any other suggestions, Wey-Wey, or?
Well, I just think that, if when they get this Medicare change of status notice in the hospital, if they or, a family member or friend, just making that call to the QIO, if, and that'll get the ball rolling, at least get them one independent review by the QIO on this issue, looking over the medical records to see, did their doctor have a reasonable basis for thinking they'd be in that hospital for over 2 midnights? I mean, obviously these people, just by virtue of the fact that they got the notice, they've been in the hospital 3 days or they don't have Part B. So, it's definitely worth a go giving that call to the QIO.
Either them or a family member, in the same
Yeah.
way that you would do for a discharge appeal. You get a
Yes.
notice saying you have the right, and it's actually the same. It's also a QIO for a discharge appeal.
Mhm.
And you can put in the call and just get the process rolling that way. I think that's a great way of putting it.
And I'll note that Dr. Hirsch in the chat seconded you, Ally, and said, speak to the case manager, the physician advisor, speak to that staff and find out your options. Thank you all. Any final questions or comments, Carol, Wey, or Ally? I'll take that as a no. We are right at our time limit here, so I want to thank everybody for attending today's presentation. Thank you to Ally and Wey, and particularly to Carol from Justice and Aging for taking the time out of your day to join us. Really appreciate that. Thanks to everyone for the discussion and questions. As noted earlier, everyone should be receiving a follow-up email with links to slides, recording, and the other resources that were noted today, as well as a brief survey. Please let us know how we did today. And someone requested the chat. I'll see if I can't get the chat saved and sent out as well. So thank you all again, and I will now conclude today's presentation.